I'm Josh Gablin of Gablin Law. In this video, we're going to be looking at a Farnsworth v. Meta Platforms update of the Generative Artificial Intelligence copyright lawsuit case, and it also involves Kadrey v. Meta Platforms. We're going to be looking at that as well. Let's dive right in here. The case is Farnsworth v. Meta Platforms, Inc. It was filed October 1st. If you haven't had the opportunity to review the case yet, please check out my video where I read and review the complaint. The complaint was filed October 1st, and on October 4th, we got an order from the judge. The plaintiffs in the Kadrey case, which is another case against Meta involving artificial intelligence copyright infringement, are ordered to confer with the plaintiffs in the Farnsworth case to discuss whether 1. The case should be consolidated with the Boyes firm and the Kadrey firm serving as co-lead counsel, or 2. The Farnsworth case should be stayed pending adjudication of the Kadrey case. Within 7 days of this order, the plaintiffs in the two cases should either submit a joint letter or competing letters setting forth their positions. The court understands Meta's position, but Meta is also free to file a letter if it wishes. So the court doesn't really want to hear anything more from Meta, but it will hear something from Meta if Meta has something more to say. It really wants to know whether or not these parties want to consolidate the cases, or if the other case should be held until the first case is finished. Now, the reason the judge is ordering this is because these cases have a lot in common. They both have similar claims, and ultimately, looking at these class actions, the potential class against Meta could be growing substantially here. So here we have a letter to the judge by the undersigned counsel in Kadrey v. Meta Platforms and Farnsworth v. Meta Platforms. The undersigned counsel in Kadrey et al. V. Meta Platforms and Farnsworth v. Meta Platforms jointly submit this letter in response to the court's minute order of October 4th, 2024, which we just read. As ordered by the court, undersigned counsel met and conferred concerning whether Farnsworth should be consolidated with Kadrey or stayed, and about leadership issues. Undersigned counsel agree that judicial economy will be served by consolidating the Kadrey and Farnsworth actions for largely the same reasons that all parties agreed the actions were related. Should plaintiff Farnsworth claims be added, he will immediately begin producing the appropriate discovery and shares availability for deposition, so there should be no delay. Subject to the court's approval, undersigned counsel agrees that Boyes, Schiller, Flexner LLP should serve as interim lead counsel, and Leaf Cabraser, Hyman, and Bernstein LLP should serve as additional counsel. Both BSF and LCHB are committed to bringing their class action experience and specific experience in the intersection of copyright and evolving technologies to this case. They believe such an arrangement best serves the interests of putative class members in an efficient prosecution of plaintiffs' claims. That's what it's all about, these class members, and growing this class here. You can see that this has signed by both firms. Now, the court mentioned that Meta could send in a letter if it wanted to, and we see that here. Defendant Meta Platforms respectfully submits this letter in response to the court's October 4th, 2024 order requiring plaintiffs in Kadrey and Farnsworth to provide their positions, and it goes through the minute order there as well, and says Meta's position is that Farnsworth action should be stayed. Kadrey involved a claim for direct copyright infringement by 12 prominent book authors, including fiction authors like Mr. Farnsworth. The Farnsworth action adds no new claim or dimension to the case. To the contrary, at the October 4th hearing, Mr. Farnsworth counsel confirmed that the claims in the two actions directly overlap and that the putative class proposed in Farnsworth is a narrower subset of, and thus entirely subsumed by the putative class in Kadrey. As Mr. Farnsworth would be part of any class that may be certified were this case to survive summary judgment, no legitimate purpose is served by his copycat's lawsuit. Conversely, consolidation of yet another duplicative suit at this late date would cause significant disruption and waste judicial and party resources. Meta would need to serve a full set of written discovery on Mr. Farnsworth and arrange to take his deposition. After receiving his responses and documents, adding to the substantial burden and expense Meta has already incurred, Meta would also have to reopen third-party discovery, including to book publishers, that has been targeted to date at the existing plaintiffs and their works. Consolidation would also add yet another law firm as additional counsel to the roster that already includes half a dozen law firms and dozens of plaintiffs' counsel. None of this is necessary for resolution of fair use at summary judgment. At this stage of the case, the parties and claims should be narrowing, not expanding. The gambit of waiting until discovery is about to close to file a copycat lawsuit should be rejected. So, as we saw in the other letter, they are open. Mr. Farnsworth is ready for discovery. And Meta is saying we don't want to reopen discovery here. They don't want to add more counsel. But also, if discovery had been limited to these existing plaintiffs in this first case, right, in the Kadrey case, then it does make sense to open discovery to get more information on the putative class. So if Farnsworth is a subset of the Kadrey class, that subset should have been included in their targeted discovery, right? At least to some degree, you would think they should have been the targets to some extent. If the court were nevertheless inclined to allow consolidation with Boy's firm as interim lead counsel, Meta respectfully submits that the court's order should include guardrails to minimize the corresponding delay, disruption, and burden to Meta. Under no circumstances should Mr. Farnsworth's late entry derail the new schedule set by the court, beyond the assurance that Mr. Farnsworth immediately will begin producing the appropriate discovery and share his availability for deposition. Any consolidation order should provide that Mr. Farnsworth and his counsel are subject to the new schedule set by the court on October 4th, subject to an ESI order, protective order, and all other orders entered in Kadrey. Mr. Farnsworth will receive all discovery served in the case to date, but may not serve any new discovery or seek any depositions beyond those sought by the existing plaintiffs. Mr. Farnsworth is required to serve initial disclosures within 1 week of consolidation. Meta may serve the same written discovery on Mr. Farnsworth that it has served on other plaintiffs, and he will be required to fully respond to that discovery and to produce all non-privileged responsive documents within 30 days. Although Meta maintains that staying the Farnsworth case while Kadrey is litigated, at least through summary judgment, is the more efficient and appropriate way to proceed, the foregoing would help, in the event of consolidation, to ensure that Meta can fairly defend itself and that the case remains on track for a May 1st, 2025 hearing on summary judgment. This is from Meta's counsel. So October 4th was the minute hearing. October 11th, we see plaintiff's counsel in Farnsworth and Kadrey submits the letter, and on October 14th, we had Meta submit their letter to the court. Now, on October 18th, this past Friday, we got an order from the court. The request to consolidate Kadrey and Farnsworth is granted. Kadrey will serve as the lead case, and the clerk is directed to close the Farnsworth matter. If the addition of the Farnsworth matter results in any delay in the case schedule, the court will reverse this order, reestablish the Farnsworth matter as a separate case, and stay that case pending resolution or adjudication of the Kadrey matter. Boyce, Schiller, Flexner is appointed interim lead counsel in the consolidated matter, with Leif, Cabraser, Hein, and Bernstein serving as additional counsel. So, against Meta's wishes, they're going to have to deal with this consolidated case in Kadrey and Farnsworth. They're going to have to go through a little bit more discovery here, and the case, the class, I should say, is probably going to grow. If they are consolidating these, the potential plaintiffs, the putative class, seems likely to expand. We'll definitely keep an eye on this and keep you updated. If you've enjoyed this video, please like and subscribe so you don't miss further updates.